Okay, good evening, everybody. It's 7:03, so we are definitely late. For an Italian, time is very important, as you know. I'm kidding, of course.
Oh, we need to turn the mic on.
Good evening, everybody, and welcome to Loyola Marymount University, for those of you who are coming from the community. My name is Roberto Del Loro. I'm the director of the Bioethics Institute. And I will be moderating the evening and introducing our speakers. The topic for the evening, as you know, is the euthanasia debate, international perspectives. I think we have a very good evening ahead of us, even if the topic is not exactly cheerful. Still, knowing the main speaker for this event, Professor John Keown, I'm pretty sure that there will be some humorous moments as well. So, I also want to thank Professor Chris Kaiser from the philosophy department, who will provide a response to Professor Keown, and I will introduce him properly later. So let me now officially greet John Keown and thank him for accepting the invitation to be our last speaker in the Bioethics lecture series for 2013-2014. Never was the adagio last but not least more appropriate than for this occasion, since the scholarly accomplishments of Professor Keown are so impressive and many that for sure I will not be able to do justice to him if I mention only the main stations in his academic career. So John Keown comes from Georgetown University, where he is the Rose F. Kennedy Professor of Christian Ethics at the Kennedy Institute of Ethics. He graduated in law from Cambridge and later took a doctorate in philosophy at Oxford. He was called to the Bar of England and Wales, winning the prize for advocacy, and soon became the first holder of a newly created lectureship in law and ethics of medicine at Cambridge, where he was elected to a fellowship at Queen's College and later a senior research fellowship at Churchill College. Professor Keown's research has been cited by distinguished legal bodies worldwide, including the United States Supreme Court, the House of Commons, the House of Lords Select Committee on Medical Ethics, and the Australian Senate, before which he was invited to testify. He also served as a member of the Ethics Committee of the British Medical Association and has been regularly consulted on legal and ethical aspects of medicine. His list of publications is very large, comprising many scholarly articles in various journals and 7 books. Among them, Abortion Doctors and the Law, Euthanasia Examined, Euthanasia Ethics and Public Policy with Cambridge University Press. Then there was a kind of switch of publishers at some point, and so the latest books, The Law and Ethics of Medicine and Reason, Morality and Law, came out with Oxford University Press. So it's a great honor to have John Keown here tonight. Please join me in welcoming him for our lecture.
Well, thank you, Roberto, for that very generous introduction, and thanks to all of you for coming this evening on what is a beautiful California evening. I'd like to thank Roberto not only for inviting me, but for getting me away from the drizzly weather in DC and into the sunshine of Los Angeles. I'm glad that Roberto said he would be moderating the panel this evening. It's not often that you hear the words Italian and moderate in the same sentence, but there we go. And it's all right, I've got my fee already, I can do it. And as he said, although this is a very serious topic I'll be addressing this evening, I think a certain amount of levity, at least to begin with, is not inappropriate. So I ransacked my store of humorous stories about the end of life, and I came up with this one, which I hope you enjoy, about a Scotsman called Paddy MacDonald. And Paddy MacDonald dies and goes up to the pearly gates, and he's walking through into heaven when St. Peter says, "Oi, stop, where do you think you're going?" And Paddy says, "My name's Paddy MacDonald. I'm a Catholic. I'm going to heaven." And St. Peter says, "Well, I'm afraid it's not that easy anymore, you know." And Paddy says, "What do you mean? I'm a Catholic. I'm going to heaven." And St. Peter said, "Well, I'm afraid we've got some new guidelines for admission. And number one is, what have you done for ecumenism?" And Paddy says, "What the hell's that?" And St. Peter says, "Ecumenism, what have you done to reach out to people of other faiths?" Paddy says, "Oh, I have done that. And St. Peter said, "Well, we need examples." So Paddy says, "Well, you know, in Glasgow, I'm from Glasgow in Scotland, and you know there are two football teams. There's Glasgow Celtic, that's the Catholic team, and there's Glasgow Rangers, that's a Protestant team." And St. Peter said, "Yes, I know that. Well, what of it?" And he says, "Well, look, of course, I'm a Glasgow Celtic supporter. And I was the first Glasgow Celtic supporter to go and stand alongside the Glasgow Rangers supporters." St. Peter said, "That's incredible. That's wonderful. That's just what we want to hear." Now he said, "Can you just give me a few details? When did this happen?" And Paddy said, "About 30 seconds ago." So my talk this evening is going to be about euthanasia, international perspectives. And obviously it's a huge topic, and I'm not going to be able to cover all the international aspects of the subject, so I won't even try. What I am going to talk to you about is an important and current case from Canada, which raises many of the key issues which are at the core of the debate about the legalization of euthanasia. And this is a case called Carter against Canada. And basically, I'll be analysing the decision of the judge, which has been appealed, and the case will actually be heard by the Canadian Supreme Court in October. So let me, without more ado, start by saying a little about terminology, because, of course, it's important to be clear about what we're talking about. I'm going to use the word euthanasia. There's no universally agreed meaning. To mean the intentional termination of a patient's life by a physician, because it's thought to benefit the patient. So we're talking about the intentional, that is purposeful, shortening of life, not actions or omissions that result in the foreseeable shortening of life. The intentional termination of a patient's life by a physician. The current debate about whether the law should permit euthanasia is about whether doctors should be allowed to intentionally terminate patients' lives. And why? Because it's thought to benefit the patient. We're not talking about cases where doctors selfishly kill patients, where doctors end a patient's life because the doctor thinks it will benefit the patient, typically by alleviating or ending the patient's suffering. So that's how I'll be using the word euthanasia. And we can subdivide that into active or passive euthanasia, where the doctor carries out his or her intention by an act, such as a lethal injection, or by an omission, such as a withdrawal of life support. But notice passive euthanasia would only be where an omission is carried out with the intention to end the patient's life. So we're not talking about those many cases where doctors withdraw or withhold treatment because the treatment is futile or too burdensome, and the doctor merely foresees that the patient will die sooner rather than later. Another important distinction is between voluntary, non-voluntary and involuntary euthanasia. Voluntary euthanasia, where the patient has requested that their life be ended. Non-voluntary euthanasia, where the patient is incompetent to make a request, so the patient's like a baby or has advanced senile dementia. And involuntary euthanasia, where the patient is competent but does not want to be terminated. My focus tonight will be on voluntary active euthanasia. The current debate in many parts of the world is whether the law should be changed to allow doctors to give lethal injections to patients who want it in order to put an end to their suffering. So that's the focus of my analysis tonight. Now, of course, voluntary active euthanasia, VAE, is in most countries in the world regarded as a form of homicide and would typically be charged as the crime of murder. Related to that is physician-assisted suicide, or PAS, where the doctor provides the patient with the means to commit suicide, typically by writing a lethal prescription for drugs which the patient then subsequently takes. That, in most jurisdictions in the world, is the crime of assisting suicide. As we'll notice, in one or two jurisdictions, voluntary active euthanasia is permitted or physician-assisted suicide is permitted. We'll say a little about that later on. So that's just my basic introduction to terminology. We're basically talking about here, in those countries, like many states of the United States or many countries around the world, where lethal injections and lethal prescriptions are prohibited, should they be allowed? That's the focus of the current moral and political and legal debate. Now I'm going to talk to you about the Carter case in Canada, which is a very important case and which may result in the legalization of voluntary euthanasia in Canada. It'll all turn on the decision of the Supreme Court later this year. It's a decision of the Supreme Court of British Columbia, a decision by Madam Justice Lynn Smith, who found that there is a right to voluntary euthanasia and physician-assisted suicide in Canadian law. She held that sections 7 and 15 of the Canadian Charter of Rights and Freedoms operate to give people a right in certain circumstances to voluntary euthanasia and physician-assisted suicide. And her important judgment, her important conclusion to that effect, turns to a large extent on her factual finding that evidence from those few jurisdictions which have relaxed their laws and which allow either voluntary euthanasia or physician-assisted suicide shows that the risks of decriminalisation can be very largely avoided through carefully designed, well-monitored safeguards. Now, Section 7 of the Canadian Charter of Rights and Freedoms provides that everyone has the right to life, liberty and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And Madam Justice Smith held that that section grounded a right to voluntary euthanasia and to physician-assisted suicide. And she also went on to look at Section 15 of the Canadian Charter, an anti-discrimination provision, which says that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, colour, religion, sex, age, or mental or physical disability. And she held that the anti-discrimination provision also grounded a right to physician-assisted suicide for those who were materially, physically disabled or soon to become so. The basic thinking here is that suicide has been decriminalised in Canada, so able-bodied people may kill themselves, but those who are physically incapable of killing themselves can't, so the prohibition against assisting suicide discriminates against them, and therefore the prohibition should be struck down because it's discriminatory. So in short, that's what Madam Justice Smith held. Now, Canada appealed her judgment to the Court of Appeal of British Columbia, and her judgment was overturned by a majority of 2-1. And it was overturned largely because the Court of Appeal disagreed with her interpretation of constitutional principles. But my paper doesn't really concern Canadian constitutional law. It concerns a number of other criticisms of her judgment, which the Court of Appeal of British Columbia didn't touch upon, and which therefore remain relevant when the case will be heard by the Supreme Court. Now, Madam Justice Smith's decision was surprising because 20 years ago, the Supreme Court of Canada, in the Sue Rodriguez case, rejected the argument that there is a right in Canadian law to physician-assisted suicide. But Madam Justice Smith, in the Carter case, thought that the principle of disproportionality in Canadian law had since changed, and also that we now had fresh empirical evidence from those jurisdictions which allow euthanasia or physician-assisted suicide, and she thought she was therefore entitled to reconsider the question of whether there is a right to physician-assisted suicide or voluntary euthanasia in Canadian law. Now, I'd like to suggest 4 criticisms of Madam Justice Smith's judgment in the Carter case. And it's a judgment we should bear in mind, which is out of line with decisions of the Supreme Court of Canada in the Rodriguez case 20 years ago, the Supreme Court of the United States, the House of Lords, and the European Court of Human Rights, and more recently, the Supreme Court of Ireland. And it's also a decision which is inconsistent with the vast majority of expert committees and legislatures which have considered, for the last 75 years, whether voluntary euthanasia could safely be decriminalised. So I identify 4 central flaws in Madam Justice Smith's judgment. Firstly, its failure accurately to appreciate and affirm the fundamental legal principle of the inviolability of human life, a principle which has historically provided a bright line between, on the one hand, intentionally ending the lives of patients, euthanasia, and on the other, treatment aimed at palliation and the withdrawal of treatments because they're futile or excessively burdensome, where the shortening of life is merely foreseen. My second criticism is its holding that the prohibition on assisting suicide discriminates unfairly against those physically unable to commit suicide. The third criticism is the judgment's evasion of the important argument that once the inviolability principle is abandoned by the endorsement of voluntary euthanasia, such endorsement logically entails the endorsement of non-voluntary euthanasia, the euthanasia of patients who are incapable of making a request. And the fourth criticism concerns what I regard as the judge's erroneous finding that the experience of jurisdictions with relaxed laws shows that the risks of decriminalisation can be very largely avoided through carefully designed, well-monitored safeguards, as she put it. So basically my presentation will look a little more closely at these 4 criticisms of her judgment in the Carter case. So first, let's turn to the first criticism, misunderstanding the inviolability of human life. What is this principle? Well, the principle of the inviolability of life is a fundamental principle of the common law. The principle has historically been referred to as the sanctity of life, but I'm concerned with a philosophical rather than a theological principle, and therefore I prefer to call it the inviolability of life. As Lord Gough noted in the leading English case of Airedale, Trust and Bland, this principle has long been recognised in most, if not all, civilised societies throughout the modern world, as is evident from Article 2 of the European Convention on Human Rights and Article 6 of the International Convention on Civil and Political Rights. The principle is grounded in an understanding of each human being as having an intrinsic and ineliminable dignity. And the essence of the principle is the prohibition on the intentional taking of human life, intention used in its ordinary sense of aim or purpose. The House of Lords Select Committee on Medical Ethics, one of those several expert committees which carefully considered the case for voluntary euthanasia and rejected it, described this prohibition on intentional killing as the cornerstone of law and of social relationships, which protects each one of us impartially, embodying the belief that all are equal. The judgment of Justice Smith fails, however, to exhibit an accurate understanding of this important principle, to recognise its foundational importance in the law, to provide anything approaching a reasoned case for rejecting it, and to appreciate that its rejection cannot logically be confined to the circumstances she adumbrates. Now, at the heart of this principle is the key distinction between intending to end a patient's life and merely foreseeing that through, say, palliative care, one may incidentally shorten their life. This key distinction has been endorsed by a number of Supreme Courts, by the Supreme Court of Canada in Rodriguez, for example. Delivering the judgment of the majority in that case, Justice Sapinka rejected the argument that assisting suicide was similar to the withdrawal of life-supporting treatment at the patient's request. He also rejected the argument that the distinction between assisting suicide and accepted medical treatment was even more attenuated in the case of palliative treatment, where the doctor foresaw that would be hastening death. Justice Sapinka observed, "The distinction drawn here is one based upon intention. In the case of palliative care, the intention is to ease pain, which has the effect of hastening death, while in the case of assisted suicide, the intention is undeniably to cause death." He added, "In my view, distinctions based on intent are important and in fact form the basis of our criminal law. While factually the distinction may at times be difficult to draw, legally it is clear." Echoing Justice Sapinka in Rodriguez, the Supreme Court of the United States has affirmed the distinction between trying to hasten death and merely foreseeing the hastening of death. In Vaco and Quill, Chief Justice Rehnquist, delivering the judgment of the court, noted that the distinction between assisting suicide and withdrawing life-sustaining treatment is a distinction widely recognised and endorsed in the medical profession and in law, and is important, logical, and rational. Similarly, the law lords have distinguished between an intention to kill on the one hand and foresight of death, even as a virtual certainty, on the other. They have held that while foresight may be evidence from which an intention may be inferred, it is not equivalent to intention. The distinction between intending and foreseeing death is also endorsed by the Dutch. They are the pioneers of legalised euthanasia. In the Netherlands, euthanasia requires an intention to kill, not merely foresight of death. So in the light of the endorsement of the distinction between intending death and foreseeing death by the highest authorities in Canada, the United States and England, it's surprising that Madam Justice Smith should have conflated intention and foresight. No less surprisingly, Counsel for the Attorney General of Canada did little to help the judge from falling into this error. Remarkably, Counsel submitted that the criminal law does not appear to recognise the distinction between intention and foresight. But if the criminal law draws no distinction between administering drugs to palliate pain, foreseeing they will as a side effect shorten death, and administering a lethal drug in order to kill the patient, how can the former be unlawful and the latter unlawful? So in short, Counsel for Canada was sawing off the branch she was sitting on. Not only did Justice Smith misunderstand the inviolability of life by conflating foresight with intention, she also appeared to conflate the inviolability of life with vitalism. That is, with a doctrine calling for the preservation of life at all costs. So the inviolability of life is centrally about prohibiting the intentional termination of patients' lives. It doesn't require doctors to preserve life at all costs. But Madam Justice Smith claimed that the difference of ethical opinion about euthanasia is about whether the preservation of life is an absolute value subject to no exceptions. But the principle of the inviolability of life does not require the preservation of life subject to no exceptions. It's a principle excluding certain kinds of choice, choices intended to kill. The judgment also referred to the absence of societal consensus that life must always be preserved at all costs. This again suggests that the judge confused the inviolability of life with vitalism. So it seems to me that this is a significant criticism of the judgment, that the judge fundamentally misunderstood this fundamental principle of the common law, the inviolability of life, the wrongness of intentionally ending life, which is distinct from palliative care, which merely foreseeably shortens life, or withdrawing futile or burdensome treatment, which merely foreseeably hasten death. What about the second criticism of her judgment? Discrimination against the disabled. Does the prohibition on assisting suicide discriminate unfairly against those too disabled to kill themselves? Well, this second criticism, which overlaps with the first, is that the judge failed to recognise clearly, if at all, that not only are euthanasia and assisting suicide inconsistent with the inviolability principle, but that so too is suicide itself, which explains why the law has consistently discouraged suicide. This failure in the judgment paved the way for its mistaken holding that the law against assisting suicide discriminates against those physically unable to commit it. As the judgment recognised, the common law long considered suicide to be a form of homicide. The judgment noted that in 1972 attempted suicide was decriminalised in Canada, and it quoted the then Minister of Justice, who explained that this was done on the philosophy that this is not a matter which requires a legal remedy, that it has its roots and its solutions in sciences outside of the law, and that certainly deterrence under the legal system is unnecessary. But having quoted that, the judgment nowhere appears clearly to recognise that decriminalisation did not amount to an endorsement of suicide, let alone create a right to suicide. Indeed, the judge quotes the following opinion by one of the expert ethicists called by the plaintiffs. This expert said, "The role of the physician in physician-assisted suicide is limited to providing the means for the patient to do something which is itself ethically permissible. The ethical burden of justifying assistance with suicide is discharged by justifying suicide itself." But neither the law nor professional medical ethics has regarded suicide as ethical, which is one reason why it remains illegal and, in the view of the medical profession as a whole, unethical to assist suicide. Significantly, the World Medical Association has been consistently opposed to assisting suicide and euthanasia. Its statement on physician-assisted suicide, reaffirmed in 2013, reads, "Physician-assisted suicide, like euthanasia, is unethical and must be condemned by the medical profession. Where the assistance of the physician is intentionally and deliberately directed at enabling an individual to end his or her life, the physician acts unethically." And in Rodriguez, Justice Sapinka observed, "The decriminalisation of attempted suicide cannot be said to represent a consensus by Parliament or by Canadians in general that the autonomy interest of those wishing to kill themselves is paramount to the state interest in protecting the life of its citizens. Rather, the matter of suicide was seen to have its roots and its solutions in sciences outside the law, and for that reason, not to mandate a legal remedy." And it was a similar story in England, where suicide was decriminalised by the Suicide Act of 1961, where the government minister made it clear this was not done in order to condone suicide. In the case of Pretty against the Director of Public Prosecutions, the House of Lords rejected the appellant's argument that the law against assisting suicide discriminated against those who, like the appellant in that case, were physically unable to commit suicide. Lord Bingham pointed out that such an argument rested on a misconception, for the law conferred no right to commit suicide. That the Suicide Act conferred no right to commit suicide was, he said, illustrated by the fact that it remained seriously criminal to provide assistance in suicide. And he went on, the criminal law could not be regarded as discriminatory because it applied to everyone. The broad policy of the criminal law was to apply its offence-creating provisions to everyone. Provisions criminalising the misuse of drugs did not exempt the addict. Moreover, mercy killing was, he said, in law, killing. And he concluded, if the criminal law sought to prescribe the conduct of those who assisted the suicide of the vulnerable, but exonerated those who assisted the suicide of the non-vulnerable, it could not be administered fairly and in a way which would command respect. The judgment in Carter appears to equate decriminalisation with condonation. But this is, as Lord Bingham and Justice Sapinka before him indicated, a false equation. Imagine this legislature wishing to eradicate recreational heroin use, lifts the criminal prohibition on the recreational possession and use of heroin on the ground that heroin addicts can be better helped by medical treatment than by criminal prosecution, but maintains the prohibition on supplying heroin. Would this discriminate against a person too disabled to procure a supply of heroin? Would such a person be entitled to a judicially approved fix? Justice Smith asserted that the starting point in our law, the default position, is that persons control their own physical integrity. Well, yes, but within limits. The law recognises our physical integrity, our lives, and our autonomy as goods we have the right to safeguard. But it doesn't follow we may lawfully consent to the amputation of healthy limbs, to be killed, or to sell ourselves into slavery, conduct which undermines those goods. Her judgment proceeds that an example with direct relevance to this case is the evolution of the doctrine of informed consent to medical treatment. But the relevance is not, with respect, obvious. The legal requirement of consent to medical treatment provides, if you like, a shield against unwanted touching, not a sword to demand interventions. It does not follow from the fact that physicians may not treat patients without their consent, that they can terminate them with their consent. So that then is my second criticism of the judgment, that the law does not in fact discriminate against those unable to commit suicide. There is no right to commit suicide. The law has long sought to discourage it. Even after the decriminalisation of suicide, that remains the policy of the law. Third criticism was Justice Smith's evasion of the logical slippery slope argument against the legalisation of voluntary euthanasia. To begin with, Justice Smith claimed that the purpose of the prohibition on assisting suicide is protection of the vulnerable. But I think this overlooks the distinct purpose of affirming the principle of the inviolability of life, of discouraging anyone, vulnerable or non-vulnerable, from committing suicide. And in Rodriguez, Justice Sopinka observed that the purpose of the prohibition was not confined to the protection of the vulnerable. He noted that the crime of assisting suicide in Canadian law was grounded in the respect for and the desire to protect human life. This law fulfilled the government's objectives of preserving life and protecting the vulnerable, two purposes. The purpose was not only a policy of the state, but was part of Canada's fundamental conception of the sanctity of human life. In relation to protection of the vulnerable, Justice Smith concluded that an alternative to the blanket prohibition would have been an almost absolute prohibition, but allowing grievously ill and irremediably ill adult persons who are competent, fully informed, non-ambivalent, and free from coercion or duress to receive a lethal injection or assistance in suicide. But her judgment nowhere answered the objection raised in expert evidence for Canada that once the principle of the inviolability of life is abandoned by endorsing voluntary euthanasia in some circumstances, the bright line grounded in the intrinsic dignity of each patient is usurped by an arbitrary line dependent on subjective judgments about which patients would be better off dead. And that in particular, the endorsement of voluntary euthanasia logically entails the endorsement of non-voluntary euthanasia. And there are two reasons why the judgment logically involves the endorsement of non-voluntary euthanasia. The first is the judgment's conflation of intention and foresight. The judgment, you'll recall, accepted that the criminal law draws no distinction between intentionally bringing about a prohibited consequence and foreseeably doing so, at least if that consequence is virtually certain and seen as such. But if there is no legal and ethical distinction between administering potassium chloride with intent to end a patient's life and administering morphine to ease pain, foreseeing it will shorten life as a side effect, and if it's legal and ethical to do the latter when the patient is incompetent, which it undoubtedly is, then why is it not ethical to do the former? And why should it not be lawful to do so, even if the patient is incompetent? Secondly, the conditions listed by the judgment, conditions which are not confined to those who are physically unable to commit suicide, are vague. What is meant by grievously ill? Arbitrary. Why exclude someone who is almost grievously ill? Or someone who feels that their life is no longer worth living for reasons unconnected with health? And those conditions are surely largely subjective, and they cannot logically resist extension to incompetent patients. Now, this logical slippery slope argument, which is really a key argument against any relaxation of the law, is largely misunderstood. So it's important to be clear what it is. It runs that even in cases of voluntary euthanasia, it's the doctor who decides whether to grant the patient's request. And no responsible doctor will grant the request unless he or she judged that death would indeed benefit the patient, because the patient's life is no longer worth living. And once a doctor is prepared to make such a judgment in the case of a patient capable of asking for death, that judgment can logically equally be made in the case of a patient incapable of requesting death. To put it another way, if respect for autonomy and beneficence are thought to justify voluntary euthanasia, why is beneficence alone not thought to justify non-voluntary euthanasia? If a doctor thinks death would benefit the patient, why should the doctor deny the patient that benefit merely because the patient is incapable of asking for it? Tellingly, arguments thought to justify voluntary euthanasia, which were adduced by plaintiffs' two lead ethical experts and quoted at considerable length by Justice Smith, offer no answer to the logical argument. Indeed, they are vulnerable to it. And both of those experts, in their published works, openly endorse non-voluntary euthanasia. Once the law abandons the bright line prohibiting any intentional ending of patients' lives, it enters a fuzzy world of arbitrary judgments about whose lives are not worth living. And it's not surprising that disability groups in general are strongly opposed to the legalization of voluntary euthanasia. To give you just one example, a letter from disability groups in the UK and the US, which opposed the proposal to relax the law in England some years ago, stated, "We are like society's canaries in the coal mine, who can often see the dangers of potentially discriminatory legislation before others, as it impacts on us even before the deed is done. We are scared now. We will be terrified if assisted suicide becomes state-sanctioned." Remarkably, Justice Smith's judgment simply evades this logical slippery slope argument. It states that the argument requires speculation and arises only tangentially in connection with the issues in this case. Earlier in the judgment, she said, the plaintiffs in this case do not argue that physician-assisted death should be imposed on patients who do not themselves request it. Therefore, the ethical debate relevant to this case focuses on a limited class of patients, those who are competent, adults, decisionally capable, fully informed as to their diagnosis, prognosis, and all options for treatment, persistently and consistently requesting assistance with death, and not subject to coercion or undue influence. But the fact that the plaintiff's arguments do not, for the present, seek to justify non-voluntary euthanasia surely does not relieve the court of the duty to consider the obvious implications for incompetent patients and other vulnerable patients of those arguments. The evidence of the plaintiff's own experts indicates the absence of any clear or coherent limits to euthanasia, whether voluntary or non-voluntary, once the current bright, ethically coherent line offered by the inviolability of life is abandoned. And now on to the fourth criticism of Madam Justice Smith's judgment, misinterpreting the experience of those few jurisdictions which have relaxed their laws to permit either voluntary euthanasia or physician-assisted suicide. Justice Smith concluded that the empirical evidence from jurisdictions with relaxed laws shows differing levels of compliance with the safeguards. This is something of an understatement. The reality is that of the few jurisdictions which have relaxed their laws, none has demonstrated anything even approaching effective control. The best available evidence, that from the Netherlands, shows that key safeguards have long been widely breached and with virtual impunity. Since 1984, when voluntary active euthanasia was declared lawful by the Dutch Supreme Court, the evidence generated by several Dutch government-sponsored surveys has shown that thousands of patients have been killed without the required request, and that thousands of euthanasia deaths have been illegally certified by doctors as deaths by natural causes. The evidence from Belgium paints a similar picture: the common performance of non-voluntary active euthanasia in breach of the guidelines and a frequent failure by doctors to report. The evidence from the state of Oregon is much more limited. There have been no comprehensive surveys like those in the Netherlands. Moreover, the safeguards in Oregon are, in significant respects, not least the absence of review committees, such as exist in the Netherlands and Belgium, even laxer than those in the Netherlands and Belgium. The Oregon law safeguards have been aptly described by leading health lawyer Professor Alex Capron, who I'm delighted is with us this evening, as largely illusory. It's therefore odd that Justice Smith should have concluded that the evidence shows that the risks can be very largely avoided through carefully designed, well-monitored safeguards. First, no jurisdiction which permits euthanasia or assisting suicide has carefully designed, well-monitored safeguards. The judgment appears to offer no response to the evidence that control in the Netherlands, Belgium and Oregon cannot be effective because all of those systems rely largely on self-reporting by doctors. Secondly, the undisputed evidence from the Netherlands and Belgium shows widespread breach of the guidelines, not least the sizable incidence of non-voluntary euthanasia and non-reporting. Thirdly, the judgment in Carter skates over the official condemnation of non-voluntary euthanasia of disabled newborns by the Dutch courts and the Dutch medical profession. And it fails even to mention, although it was cited in evidence, the repeated criticism of the Dutch by the United Nations Human Rights Committee. The judgment also fails to give anything like adequate attention to important expert committees which have taken full account of the Dutch experience in their unanimous and considered rejection of euthanasia, not least the reports of the House of Lords Select Committee on Medical Ethics and of the New York State Task Force. And a final point I'd like to discuss relates to a more recent decision of a court from another country. This is the decision of the Divisional Court of the High Court of Ireland in the case of Fleming and Ireland. Now, in Fleming, this is a case broadly similar to the Carter case. A woman with multiple sclerosis wants to avail herself of assisted suicide at a time of her choosing, and she challenged the law in Ireland against assisting suicide. The Irish court rejected her claim and concluded that the prohibition on assisting suicide was fully justified. The court, in a lengthy and informed judgment, proceeded to consider the comparative legal authorities. It observed that apart from the judgment of Madam Justice Smith in the Carter case, there was near judicial unanimity on the constitutionality of blanket prohibitions on assisting suicide. Every appellate court had stressed as compelling the considerations which had persuaded the Irish court to uphold the Irish law. The US Supreme Court had noted the state's interest in protecting vulnerable groups, including the poor, the elderly, and the disabled, from abuse, neglect, and mistakes, and in protecting the disabled and dying from prejudice, negative stereotypes, and societal indifference. The Irish court also turned to the Supreme Court of Canada's decision in Rodriguez where it noted that Justice Sapinka had held that the blanket ban had a clearly pressing and substantial legislative objective, grounded in respect for and the desire to protect human life, a fundamental charter value. The Irish court also noted that the European Court on Human Rights had affirmed in the Pretty case that clear risks of abuse do exist, notwithstanding arguments as to the possibility of safeguards and protective procedures. What did the Irish Divisional Court have to say about the Carter case? In particular, Justice Smith's conclusion that the evidence from jurisdictions with relaxed laws showed that risks could be effectively guarded against by safeguards. Well, basically, the Irish court disagreed with Madam Justice Smith. The Divisional Court said it could not agree that the accumulated evidence from other jurisdictions supported Justice Smith's conclusion that the inherent risks had not materialised in a manner that had been predicted. The Irish court said neither the evidence tendered at the hearing before us or the evidence given before Justice Lynn Smith regarding contemporary practice in either the Netherlands or Belgium can be regarded as encouraging or satisfactory. The Irish court noted that the evidence showed that the incidence of non-voluntary euthanasia in the Netherlands and Belgium was strikingly high. The court noted that the preponderance of judicial opinion in the United States, Canada, the United Kingdom, and the European Court of Human Rights had been to uphold a blanket ban for the same or substantially the same reasons as the Irish court itself had set out. So, finally, some conclusions. I've set out my 4 flaws in relation to the Carter case. I'd just like now to touch, perhaps briefly, on 1 or 2 other points before I conclude. And the conclusion is, with respect, that the judgment of Justice Smith in Carter is profoundly flawed for the 4 reasons I have given. In short, the case rejects a foundational ethical principle of the criminal law and misrepresents the disturbing and widely recognised reality of practice in those few jurisdictions which have abandoned it. And the final points I wish to make, I'd like to raise 1 or 2 other questions about is it appropriate for courts to change the law in relation to voluntary euthanasia and or physician-assisted suicide? In the Airedale NHS Trust case in England, Lord Gough said it's of course well known that there are many responsible members of society who believe that euthanasia should be made lawful. But that result could, he said, only be achieved by legislation which expresses the democratic will that so fundamental a change should be made in our law and can, if enacted, ensure that such legalised killing can only be carried out subject to appropriate supervision and control. And reflecting that approach, the highest courts in Canada, the US, England and Ireland, together with the European Court of Human Rights, have deferred to legislatures to resolve a matter involving, as it does, questions of ethics, clinical judgment and social policy that are paradigmatically suited to legislative and not judicial deliberation. I think the Carter case illustrates the dangers of judges, not least in expedited hearings, as the Carter case was, making mistaken factual findings at odds with those of expert committees, such as those appointed by legislatures. What about the possibility of granting individuals a constitutional exemption? In the BC Court of Appeal, the 2 judges who overturned Madam Justice Smith's judgment raised this possibility of granting individuals a constitutional exemption. But this raises several questions. First, would it be proper for a statute enacted by a democratically elected legislature and upheld as constitutional by a court to be nullified by the courts even in a small number of cases? And these justices said that the issue had been raised in legislatures but without result one way or the other. But surely that statement closes its eyes to the plain fact that this issue has been raised in legislatures on many occasions and that there has been a result, that is, the repeated rejection of attempts to create exceptions. Secondly, the two justices in the BC Court of Appeal again suggested that the law's concern was to protect the vulnerable. And as I suggested, that is certainly one important purpose, but by no means the only one. And thirdly, could a constitutional exemption be limited to a small number of individuals? Are there not numerous individuals with suffering of various types and degrees? And with varying degrees of life expectancy, suffering will be more protracted the longer one's life expectancy, who might claim a constitutional exemption. And if certain individuals who requested an exemption on account of their suffering were accommodated, why deny an exemption to an incompetent person suffering to the same degree? And fourthly, leaving aside the problem of defining the limits of any exemption, would euthanasia in practice be performed only when sanctioned by a court? If many Dutch doctors ignore even the light touch regulation required of them, why should we expect doctors to subject themselves and their patients to the more formal, time-consuming and arduous process of euthanasia by constitutional exemption? So in conclusion, nothing in the judgment of Justice Smith in Carter should give the Supreme Court of Canada cause to overrule its decision in Rodriguez, a decision the soundness of which has been repeatedly affirmed, and whose soundness is significantly reinforced by the manifest unsoundness of the argumentation in Carter for overruling it. Thank you.
Thank you very much, John, for the very stimulating presentation. I'm sure we'll have time later on to debate some of those points in the Q&A section of this evening. It is my pleasure now to introduce Professor Chris Kaiser, who is a professor in the philosophy department here at LMU, and also an affiliate faculty in our Bioethics Institute. He, too, is a man of many academic accomplishments. He holds a doctorate from the University of Notre Dame and did postdoctoral work in Germany as a German Chancellor Fellow at the University of Cologne first, and as a Fulbright Scholar later on. As you probably already know, Professor Kaiser is a very prolific scholar. He published 11 books, which makes me think, what am I doing with my time? But then, yeah. 11 books on various topics, from the philosophy of Thomas Aquinas to the natural law tradition to, of course, bioethics. And so of his books in bioethics, I will mention two: A Defense of Dignity, Creating Life, Destroying Life, and Protecting the Rights of Conscience, and The Ethics of Abortion, Women's Rights, Human Life, and the Question of Justice. Please let us welcome Professor Kaiser.
Thank you for the kind introduction, Roberto. It's a real honor to be able to comment on Professor Keown's work. I've been a long-time admirer of his. And so what I want to do is actually make my comments quite brief, because I think it'll be much more valuable to hear him talk more and have you ask questions than have me drone on and on. So I'm going to be quite brief. And basically, I'm going to raise 4 different questions. The first is this. I'm wondering how Professor Keown would handle cases of suicide by means of withdrawal of care. So imagine someone who gets into a terrible car accident, and they're on life support, a ventilator, for instance. And the doctor walks in and said, well, you're going to fully recover. If you're on this ventilator for just probably 2 more weeks, you walk out of the hospital, you'll be perfectly fine. And the patient says, well, that's wonderful. And then someone visits the patient in the hospital. It's the let's say it's the husband, and the poor wife is there with the ventilator, and the husband walks in and says, honey, I know this is bad timing, but I want to tell you, I'm getting a divorce, I'm running off with the housekeeper, see you later. And let's say the woman is, really devastated by this, and she comes to believe that for her life really is no longer worth living. So when the doctor comes back in, she says, well, I want you now to turn off the ventilator. And the doctor says, well, why? I told you, you're going to be fine. Just wait 2 weeks and you'll walk out of here. And he says, yes, I understand that, but I want no more life support. I feel as if my life is not worth living any longer. And so in this case, the patient's not turning off the life support because the patient or the doctor thinks that the treatment is more burdensome than beneficial. The life-sustaining treatment is rejected precisely as a means of committing suicide. In other words, her goal, her intention, is precisely to end her life. And if you turn off the ventilator and she survives, her plan would have been thwarted. So my question is this. The doctor here seems to be in a kind of dilemma. If the doctor turns off the ventilator, isn't this a case of physician-assisted suicide? Right? The patient wants to die, and the doctor's helping the patient carry out the suicidal intention. On the other hand, if the doctor refuses to turn off the ventilator, isn't this also morally wrong? Because then the doctor is forcing treatment on an unconsenting patient. And that also seems wrong. So it seems whatever the doctor does, either turning off the ventilator or not turning it off, either way the doctor is doing something wrong. Second question. Professor Keown writes at one point in his paper, quote, however, the evidential problems which may exist in determining a patient's intention have scant bearing on the reality and importance of the conceptual and psychologically, that is humanly, factual and real distinction, a distinction which explains why administering morphine with intent to ease pain, merely foreseeing the shortening of life, is lawful and endorsed by professional medical ethics, whereas on the other hand, administering morphine with the intent to shorten life is murder and rejected by professional ethics. So here is the distinction he talked about between intending some effect on the one hand and foreseeing effect on the other hand. But here's the difficulty. The criminal law must deal with evidence. The criminal law has to, right? That's what it's about. But if there are evidential problems determining whether a particular effect is intended or foreseen, what that makes it sound like is that there's a difficulty in using the intention-foresight distinction in matters of law. That is to say, if intention is difficult, if it's hard to figure out and provide evidence whether a particular effect is intended or foreseen, that calls into question the intention-foreseen distinction's importance with reference to matters of law. Third question. I'm wondering how Professor Keown would handle this case. You have a 93-year-old man who is incompetent. He has advanced Alzheimer's. The 93-year-old man also has a pacemaker, and the battery in the pacemaker is running out. And if the new battery is not put in, the patient will die. I'm wondering, on his view, if replacing the battery is a treatment which is more burdensome than beneficial in this case of the 83 or 93-year-old man with Alzheimer's. And the final question I'd like to ask has to do with this quotation from Professor Keown's talk. Quote, as reflection on the ordinary case of theft easily shows, the thief's intent to get the thing, temporarily or not, just is the intent to deprive the owner of it. And the fact that some thieves do not think of the owner's loss, but only their own gain, does not mean that the owner's loss is a mere consequence and side effect. Rather, even in such a case, it is one and the same intent looked at from different angles. The thief's gain is the owner's loss. Intention of the one is intention of the other. The thief cannot get his gain save by means of depriving the owner. Similarly, the abductor cannot achieve his unlawful control over the child save by means of depriving the parents of such control and possession, unquote. So my question is this. What happens in the case when someone takes the property of another, not realizing it's the property of another? In this case, the person's intent to get the thing, temporarily or not, does not include the intent to deprive the owner of it. But this contradicts the claim that the ordinary case of theft easily shows that the thief's intent to get the thing just is the intent to deprive the owner of it. So I'm wondering what he would say about that last case of someone who does an unlawful action of theft, but does it unintentionally, as it were. For instance, someone making a mistake, thinking that the coat they take from the coat rack is theirs when really it's someone else's. So materially speaking, they've stolen something. But formally speaking, they haven't. So I'm wondering what he would say about that fourth case. So those are the 4 questions, and I look forward to hearing from Professor Keown and also hearing from all of you. Thank you.
Can I phone a friend? Okay, so let's take them in order. So we have the clearly suicidal refusal of ventilation. That's number 1, isn't it? You'll notice that Professor Kayser considered 2 possible answers to that, both of which were wrong. I think only a philosopher could come up with 2 answers, both of which were wrong.
I could come up with a third wrong answer, I'm sure.
Well, I think the first thing to do would be to consider the competence of the patient. Because one thing that's often overlooked is that a desire to die is often associated with clinical depression. So, of course, many people would be tempted to answer the question by saying, well, it's her decision, pull the plug. But, of course, that would be too facile. I think one would have to seriously consider whether this person was truly competent. Let's say there was a psychiatric evaluation and the patient was competent, but nevertheless suicidal, which can, I'm sure, happen. I mean, there is a very interesting statement on this whole question by the Royal College of Psychiatrists in London, who said that people who are on life support or in the medical context who want to die are often a victim of clinical depression, just as people who throw themselves off bridges. So the fact that it happens in a hospital doesn't mean they're automatically competent. And that once the depression is treated, I think the figure was 98 to 99% of them change their mind about wanting to die. But let's say that the patient is competent, and we're dealing with a clearly suicidal refusal of treatment. Then I think one could withdraw that treatment without intending to assist them to kill themselves. So the doctor's state of mind might well be, well, for one thing, counsel to the hospital tells me that continued treatment without consent is an assault. So I'm required by law to turn this off. So my intention in turning it off is to abide by the law. And in that sense, to sort of say, well, I'm respecting your legal right of refusal. So I don't think it follows that even in the situation where the patient's clearly suicidal, a doctor complying with that refusal is intending to help that person to kill themselves. Of course, it might be. So the doctor shouldn't say, I think that's a wonderful idea. Let me flip the plug now. And we'll have a couple of glasses of champagne before we do it. So that's the first scenario. The second question in relation to evidence and the criminal law. I don't think this in any way invalidates the importance of the conceptual distinction between intention and foresight. The House of Lords Select Committee, which I mentioned more than once, dealt with a similar kind of question when people said to it in evidence, well, look, this distinction you talk about between intending to end the patient's life and merely foreseeing, how are you supposed to know what's going on in the doctor's mind? It's a purely kind of artificial conceptual distinction which doesn't translate into the real world. And the House of Lords Select Committee replied, well, we don't accept that. We think there is an important distinction between intending to shorten life and merely foreseeing the shortening of life. And it's a distinction which juries have to grapple with every day of the week in criminal cases up and down the country. So there are lots of crimes where the prosecution has to prove an intent to do something, and the jury has to decide on the basis of all the evidence whether it was indeed the defendant's purpose to bring about that prohibited consequence. So I don't think the factual difficulties that can exist, and they can of course exist, in any way undermine the reality of the conceptual distinction between intending and foreseeing a consequence. I like using the example, was it Oliver Wendell Holmes, who raised this, and I use it in one of my books, where imagine you're living in a small condo. Now, I know the prices out here, from what I'm told, are as bad as in Manhattan and Washington, so probably a lot of you have to live in a very small apartment. And I know, obviously, many Americans are dog lovers, and so some of you will have maybe a dog or two, a Great Dane or something like that. Now, you know, sooner or later, you know, you may, while the dog's sleeping, you may step on the poor dog's nose, and the dog will whine or bark or growl or whatever Great Danes do. But surely that's quite different from if you're annoyed with the dog or you've had a bad day at work, coming home and kicking the dog up the snout, you know, because even the dog knows the difference between being tripped over and being kicked. And I think that's just a humanly real distinction between an intention to bring about an injury and foreseeing the doing so, which may be permissible. The pacemaker example, now as I get closer to 93 and as I get increasingly close to Alzheimer's, I'm more sympathetic with the patient here than had you asked me this 10 years ago. I think this is one of those questions in relation to whether a treatment's beneficial, whether its burdens outweigh the benefits. One can raise all sorts of really nice, difficult questions, which I'm sure you do in your philosophy seminars, Chris, precisely like this. And in a sense, my paper is not focusing on those sorts of questions. I mean, I'm happy to give an opinion on it, but I don't think that, in a sense, those sorts of questions about the benefits and burdens of treatment are necessarily raised by the debate about whether we should give patients lethal injections. So I could see arguments maybe both ways on replacing the batteries. I think we'd need to know a lot more about the circumstances of the case would be my answer before coming to a conclusion on that. And finally, the theft example. Well, the law of theft is defined, certainly this is the case in England, which I suspect is representative of the law in many jurisdictions, in terms of the dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. So it's built into the offence that you know or believe this belongs to somebody else. So given that, if you take it, whether you are adverting to the fact that the person's going to lose their watch or their wallet or their gold bullion doesn't change the fact that it's your intention to deprive them of that watch or wallet or gold bullion. So that would be my answer to that. I didn't need a friend after all.
Okay, thank you. We are going to open it up for questions from the audience. If you could be so kind to introduce yourself, your name, and where you're from. Paul?
Hi,
Dr. Paul Schneider.
Thank you. So as a practicing hospitalist and an ethicist, I particularly resonated with your comments about the shield and the sword. And the problem is that I so frequently feel that a sword is being held against my throat and the collective throat of the hospital in which I work. I could give you more examples than you would like to hear about how my hospital is held hostage on an almost daily basis by particularly entitled patients who have an axe to grind, a grudge, a fight, and who know what they want and are going to force what they want by whatever means necessary. So the therapeutic relationship which we are supposed to have has been turned into a somewhat violent relationship, at least conceptually. And I'm all the time having to reflect on this and say that perhaps divorce with this patient is a really good option and that we need to disengage. But this is depressing because it shows that our society is much more fractured than perhaps we like it to be, and it's of course practically makes all the ethics that we talk about extremely difficult to enact on a practical level. So I just wanted to provide that back to you and see if you had any comments about that.
Thank you for that. Could I just make two points? First, thank you for your point about disengagement, because that's a point that could also be made in relation to
I think so.
Is it working? Yes. I think it's changes in the night, if you like. Because in relation to Professor Casey's question about the clinically suicidal refusal of treatment, I think that's another option for the doctors to say, well, I'm just withdrawing from the case. You'll have to get somebody else to do this, because I can't legitimately do this. Because I think it's just, okay, I could say I'm just respecting right for treatment, but I also think it's involvement in something I regard as ethical. Interestingly, we had a case in England, very much like that, what I call a case of Green, where a ventilator-dependent woman insisted on being disconnected. And the case went to court. Strangely, the judge did not raise, and counsel didn't raise this question. Is this not clearly a suicide refusal of treatment? And if so, what are the legal implications of that? It was just treated as a straightforward kind of refusal of treatment case, and she'd been analysed to ensure she was competent. But it does seem to me that just withdrawing from the case would be an option the doctor might have there. But no, I appreciate your point about the extent to which some patients abuse their right to autonomy and try and wield it as a sort of weapon, as a shield. And because, of course, the relationship shouldn't be in any way domineering one way or the other. And if patients have autonomy rights, which they do, well, so do doctors, and they should be respected. And I think often they're not, so thank you for that.
Other questions? Professor Capron?
Alex Capron. I wonder, John, if you were to set aside your argument on the equivalence, or the non-equivalence, of intention and foresight, do you feel that creates a fatal flaw in the rest of your objection and in the overall persuasive case that you make why it would be wrong to recognize through judicial decisions at least, and I suspect you would also say the legislature should not also, either physician-assisted suicide or voluntary active euthanasia by physician. Is that the fulcrum of the argument, or is that an argument that you can set aside? Let me explain why I ask that. It seems to me that there certainly are cases, Professor Tizard gave you one, where it was very easy to see that the person was refusing treatment because of an extraneous reason to commit suicide, not connected to the treatment itself. It was adventitious that she happened to have had this accident. She would have been suicidal if her husband had come in and she never had the accident, but she wouldn't have been dependent on a ventilator. But I suspect that in a large number of cases in which people are refusing treatment, speaking only of patients who are competent, where the treatment is what keeps them alive. Not just ventilators, patients on dialysis, long-term dialysis. If you ask them, do you want to be dead, they would say, no, I don't want to have kidney failure. But since I do, and I've had years of treatment, I've gotten to the point where I'd rather be dead than continue treatment. And they stop their treatment. And in most cases, if they have a good doctor, there's been a lot of discussion back and forth and trying to see if there's some psychiatric, clinical depression that should be dealt with, and if so, dealing with it, but recognizing that people come to that point. To me, it's very hard. It's not just as a matter of proof that we always judge intentions through constructing what the action was and its likely consequences. Very often we do that and say, well, if those consequences were so likely, you're denying you intended it, but we believe that that's the only conclusion we can have. So if that is an argument, at least to me, that there are many cases where we accept an action with the intention of causing death, and we do not hold it blameworthy because it is brought about through the vehicle of withholding or withdrawing treatment at the wish of the patient. If that's the case, I'm persuaded by everything else you say, but I want to know if you think that without that, your argument would fail.
It seems to me in a lot of the cases where, say, someone on dialysis or on chemotherapy is saying, I've had enough, I don't think it is certainly it needn't be the case that they say, I'd rather be dead. So I question whether in many cases it is actually a suicidal refusal.
John, could you accept that it is in some cases?
Oh, in some cases, of course.
So
yeah,
looking at those cases,
yeah.
we don't accuse the doctor of assisting suicide. No one would do it there. And I don't think we even question the person's medical ethics in allowing the patient to do that. Now, the alternative would be to put the patient into a psychiatric ward and dialyze them and restrain them. But it could also be a case where a patient is on a ventilator and it is not walking out of the dialysis unit that brings about the death, but rather persuading the doctor, I don't want any further ventilation.
Yeah, if it's doctor, I don't want any further ventilation. Not because it's burdensome. In fact, you know, it's okay. I've got used to it. But I just want to be dead. And so one way of making me dead is for you to switch this machine off. And the doctor says, yeah, I think I'm very happy to do that. I want to assist you in that objective of putting an end to your life. Then I think morally it's very difficult to see a distinction between that and the doctor writing a lethal prescription. And not least because, as we know, the distinction between acts and omissions can be very fine. Is flicking that switch an act or an omission? So I think intention is key, absolutely key. And I think those philosophers and lawyers who are advocating a change in the law and say what's happening is no different from giving lethal injection just in suicide, need to be answered, because if we say actually there is no difference, so if as counsel for the Attorney General of Canada was saying there's no difference between intending and foreseeing a consequence, then what is the moral difference between flicking the switch, saying yes I want to help to make you dead, and writing a lethal prescription saying yes I want to help to make you dead? If there's no moral difference, why does the law continue to draw one? So I think it's a very important distinction on which the law must rest. Now, obviously, there are other subsidiary or collateral arguments as well as why the law should be changed, but I think this is a really key ethical point, the importance of maintaining the line against trying to make the patient dead or trying to help the patient make the patient dead.
I have a question. Yes.
My name is James Vitale. I'm a graduate from the class of 2000. Just a question to Dr. Keown. If we were to flash forward, let's say 50 years from now, and euthanasia had become broadly legalized in the form that you described in let's say, most first world countries, what would be your greatest fear for the impact it might have on the ability for our medical professionals, our doctors, to honor their vocation and respect the Hippocratic Oath? What in your vision would be potentially the ramification, probably negatively, on their ability to affect their profession in a meaningful way?
Well, I hope I'm around in 50 years to answer that question. But I think if the law is changed and euthanasia becomes an established part of medical practice, I think we'll see quite a different medical profession than the one we have today. I think the change in the law would be something of a paradigm shift, which is how some of the witnesses before the Irish Divisional Court expressed it. It wouldn't be any longer a Hippocratic tradition of medicine. Euthanasia would be part and parcel of everyday treatment options. And I think we can see this in countries like the Netherlands, where it's taught in medical schools. It's not an exceptional event, it's now on the agenda. So in a sense, sometimes the question for the patient is, well, why don't I ask for euthanasia? Not why should I ask for it, but why don't I? It's there. So I think there'll be profound changes. Also, there'll be profound changes in the medical profession, there'll be profound changes in society, the way we view the elderly, the way we view the demented, and those with disabilities. There's a very good essay which I sometimes quote in a book edited by a leading advocate of decriminalisation. And the essay takes no view on the ethics, but says, from a cultural perspective, make no mistake that changing the law would have profound consequences, such that a lingering death would come to be seen as an extravagance. And that, so it's not as if you change the law, everything stays the same. The law would have profound changes at all levels of society, and not least so in the medical profession.
There are some dystopian writers who have even postulated that this is could be a first step towards a societal viewpoint where there becomes an honor in making a decision that after the age of a certain cutoff point, the society voluntarily chooses to end life. Because why go beyond that age? Because there's so much indignity to be faced if we go beyond that age. And they've written books along those lines. Entire societies have adopted that practice.
Certainly, it seems to me that it's an illusion to think that voluntary euthanasia is all just about the individual and the individual's autonomy. We're talking about changing the law, and the law is reflecting society's judgment. So if we change the law to allow euthanasia in this condition or that condition, then we as a society are saying, in those circumstances, we actually think that death would be a benefit for you. So I think that's absolutely right. And then it becomes quite arbitrary as to where we make our judgment about what kind of life is a benefit. The definition put forward by the plaintiffs in the Carter case is wider than the one adopted by the judge. And they were talking about psychosocial suffering from a serious illness or disability, etc., etc., and with assistance being provided by lay people, not just physicians. So it seems to me once one takes that step, one really opens up a kind of a vista of all sorts of possibilities. And certainly one of the latest trends in the Netherlands is growing support for euthanasia for those who are simply, as it's called, tired of life. Who say, I'm elderly, I'm physically healthy, but I'm lonely. My friends have died, and I'd just rather be dead. Now, over 10 years ago, the Minister of Health, who steered the legislation through the Dutch Parliament in 2002, came out and said, I don't see what's wrong with that. If you're tired of life, if you've got this existential suffering, then you should be able to be assisted in suicide. So the Dutch courts have rejected that so far, but it seems to me there's growing support in the Netherlands for euthanasia on that kind of ground.
Thank you.
So I'm Bree, I'm from the law school, and I'm really struggling with this as somebody who lost someone, a best friend, to suicide and tried desperately to save him. I feel very strongly about wanting to preserve life and help people who suffer from different illnesses. I work with people with different kinds of impairments, so I'm very sensitive to those concerns and disability rights organizations. But I'm also struggling with kind of what this area says about how we value life. And one of the things that I thought was interesting, so I have not looked closely at the Oregon experiments. I'd love to hear more about what you think and Professor Capering say about how it's actually working in practice. One of the things I've heard, so I have no idea if it's true, is that in the course of the regulatory scheme for increasing access to physician-assisted suicide, that it actually got more people into mental health or got them better pain treatment. So I have no idea if that's true or not. I'd love to know if it is, because it seems interesting to me that it takes that before, in many cases, we construct a system. So I do healthcare, and so we've let people languish, and we've made it very difficult for people to get mental health and very difficult for people to get adequate pain management. And it's not until they say, okay, enough is enough, in many of these cases, I'm done, this is horrible, and that we want to force people to keep living that way. And through that kind of scheme, that maybe we can get them more help. And so to me, one of the things this really does make me question is, why are we valuing life in this way? And what does it say about how we value life?
I think defenders of the Oregon law would argue that palliative care has improved since the law was passed. So I wouldn't rest my criticism of Oregon centrally or at all on the allegation that it's deteriorated. I mean, I've read evidence going both ways, but I wouldn't, and certainly Justice Smith in Carter said on very review of the evidence that it didn't appear that palliative care had suffered as a result of the legalization of physician-assisted suicide. But I think one fact to bear in mind is that palliative care isn't necessarily a key player in Oregon, because the reasons that people give for wanting assisted suicide are not really pain. I mean, that's part of it, but the most popular reasons given are loss of autonomy and decreasing ability to do things that make life enjoyable. So the greater ability of palliative care is not really necessarily going to reduce those two motivations for accessing assisted suicide. I've been more concerned about the very low rate of referral for psychiatric or psychological evaluation. I think over the period that the Act's been in operation since 1997, about 6%, maybe 6% of people have been referred for psychiatric evaluation. And given the evidence from psychiatrists that a desire to die is often associated with clinical depression, I think a lot of people are concerned about that statistic. So that would be my immediate response to your point, and I'd just like to have my condolences on loss of the things. You have another question?
Yeah, I have a question more on public policy. And I mean, this whole concept of actually, the courts now deciding that there may be lives out there not worth protecting, in essence. But from a public policy standpoint, what are the potential ramifications, or where does this lead us in terms of the state and the government now superseding individual choice and perhaps getting into the business of choosing who the winners are and the losers are in terms of how we allocate our medical resources? And I don't know if that is off track here, what you're talking about, but there are ethical implications when you open a door such as they have with euthanasia or physician-assisted suicide. What's to stop the state from seeing a particular role or public policy in how in how we pick winners and losers with respect to the allocation of resources?
Yes, thank you. I don't think the question is at all off track. I think it's very closely related to concerns that many people have about relaxing the law. Partly echoing something I said earlier, that changing law is a community judgment, that in certain circumstances death would benefit you, or the next step might be death would benefit the community. And we don't hear much in the way of, well, we should legalise euthanasia because it's save a fortune. Occasionally one hears voices, and I suspect some people think it more than utterly. We had a leading British bioethicist saying a few years ago openly that if you're demented, you are wasting the resources of the National Health Service and wasting the resources of your family. So I think if the law were changed, if one took the view that in certain circumstances death would benefit patients, well, why not say, yes, in certain circumstances death would benefit the community? And let's face it, all of our countries, the United States, the United Kingdom, are under enormous financial pressure in relation to healthcare. So it would be naive, it seems to me, not to see certain concerns arising here for those who were demented, those who were elderly. More often years, they use up so many resources in the last few years of life. So I think there'd be a real risk that certain vulnerable sections of the community would come under, should we say, close scrutiny in terms of their use of healthcare resources.
I have a final question, if I may, because I believe that there is a kind of elephant in the room in this conversation which we need to address, and that is the failure of the medical system to actually address properly end-of-life issues. And of course, this is a very complicated question. This is not a kind of doctor bashing sort of a conclusion. But when we discuss the question of physician-assisted suicide, physician-assisted suicide and euthanasia at the philosophical or strictly legal level, that's one thing. When we actually discuss this at the level of the public opinion, we do have to confront the fears and I would say the puzzlement about what's going to happen once I get into the hospital and once I have to make decisions that perhaps I'm not able to direct or to define according to my own autonomous play. Right, and then there's a question of what exactly is the status of that autonomy, the vulnerability of that autonomy. But the point is that many people are afraid and are in fact not confident that our medical system will be able to address those very difficult decisions in ways that take care of the basic questions. First, pain. Secondly, the integrity of their own autonomy. And ultimately also the fact that the decisions about care will be made according to the proper process, right? So how would you respond to this objection, which in a way is very non-sophisticated from a strictly philosophical, legal point of view, but in fact I think it is really what drives much of the cultural and public opinion on the question of physician-assisted suicide. Because obviously, in 1997 we had a Supreme Court decision, right, that said, well, there isn't such a thing as a constitutional right to die. At the same time, the Supreme Court decision said, let the states maintain the door ajar to define it. Well, some states have in fact opened up the door, and they have done so on the basis of a push on the part of the people. What drives this push in your opinion, and how important it is to address the mismanagement of the medical system?
I think I agree very much with what you just said, that many people are very concerned about the availability of adequate care, including palliative care, and social support at the end of life. I think it was Zeke Emanuel years ago said that the euthanasia debate is an emotionally charged irrelevance. He said very few people actually are really thinking in terms of wanting euthanasia. What they want is good end-of-life care. And many of us see loved ones die in pain, I know I have. And not surprisingly say, well, we have to change the law so that these people can get a dignified and accelerated death. That seems to me that's the wrong answer to the right question, which is how do we improve our end-of-life care? And that's a huge challenge. I'm not sure we're even beginning seriously to address that. In one of my recent books, I had a chapter just on the inadequacies in palliative care. So the British government said 100,000 people a year are dying of unnecessary pain. In a country which prides itself on the hospice movement, I find this inexcusable. And I suspect there are hundreds of thousands of people in the United States who are dying in unnecessary pain. So I think, in a sense, this whole debate is a distraction from what most people want, which is good quality care for themselves and their loved ones.
Any other question? Okay, so I think it was a wonderful conversation, also a difficult one. I suppose every one of us who's already 21 might need a stiff drink at this point. So we have a reception outside to which everyone is warmly invited, not without having thanked once again Professor John Keown.